Bar question in remedial law. Trinca borrowed 1.5 million pesos from Ida. Trinca executed a promissory note promising to pay Ida in 3 equal monthly installments. When Trinca failed to pay her obligation, Ida filed an action for recovery of a sum of money against her in the Metropolitan Trial Court of Pasay City. The case was raffled to Judge Risa, who upon reading the complaint, noticed that Trinca and Ida were neighbors in Barangay 189 in Pasay City, and that there was no prior referral of the case for barangay conciliation. Hence, Judge Risa dismissed the case motu proprio for failure to comply with a condition precedent. Was the dismissal by Judge Risa proper? Explain your answer.
Answer: no, the dismissal by Judge Risa was not proper. The dismissal for failure to comply with a condition precedent, specifically the requirement of barangay conciliation, must be in accordance with the Local Government Code of 1991, specifically Section 412, in relation to Section 6 of the Katarungang Pambarangay Law. Section 412 of the Local Government Code requires that all disputes that are the subject of a complaint filed in court must first undergo barangay conciliation proceedings. In this case, if Trinca and Ida fall under any of the exceptions specified in Section 6 of the KP Law, the dismissal would not be proper. Judge Risa should have assessed whether any of the exceptions applied before dismissing the case. Therefore, the dismissal was premature, and Judge Risa should have allowed the parties to establish whether the case qualified for an exemption from barangay conciliation or not.
Legal basis. Law. Local Government Code of 1991, Section 412. Katarungang Pambarangay Law, Section 6. Application. Section 412 of the Local Government Code requires that all disputes that are the subject of a complaint filed in court must first undergo barangay conciliation proceedings. However, there are exceptions to this rule, as provided in Section 6 of the Katarungang Pambarangay Law. The exceptions to the requirement of barangay conciliation include: where one of the parties to the dispute is the government or any of its subdivisions or agencies, where the dispute involves a crime or offense, where the dispute involves urgent matters such as child abuse, domestic violence, or violation of a protective order, where both parties agree to waive barangay conciliation, where the Barangay Conciliation Council fails to settle the dispute within 30 days from the date the complaint was filed. In the hypothetical case, Judge Risa dismissed the case for failure to comply with the requirement of barangay conciliation without assessing whether any of the exceptions applied. This was premature and improper. Conclusion. Judge Risa should have allowed the parties to establish whether the case qualified for an exemption from barangay conciliation or not before dismissing the case. Therefore, the dismissal was not proper. Additional notes. It is important to note that the burden of proving that a case is exempt from barangay conciliation lies on the party who is seeking the exemption. If either party to the dispute claims that their case falls under one of the exceptions, they must provide evidence to support their claim. If the judge finds that the case is exempt from barangay conciliation, they will allow the case to proceed in court. However, if the judge finds that the case is not exempt from barangay conciliation, they will dismiss the case without prejudice. This means that the parties can still file the case in court after they have completed barangay conciliation proceedings.
If you want more, make sure to subscribe so you never miss a video.